Okay, we're on the record in People versus Evans. This is case number 234811. If I could have counsel put your appearances on the record, please.
Thank
you, Your Honor. Jason Thompson on behalf of defendant Anson Evans.
I'm a speaker appearing as co-counsel.
All right, thank you. We're on the record here today for defendant's motion to suppress. I did have a chance to review the motion in brief, as well as the prosecutor's response, and then I also did receive a reply from the defense, which I had a chance to review prior to today's hearing. So fairly well versed in the facts and argument and law that each side's citing. So I don't know, Mr. Thompson or Mr. Seeger, did you want to present any kind of argument prior to testimony in this case?
Your Honor, I'm comfortable waiving an opening argument and letting Mr. Ziegler get to his proofs. I think we all agree that's where the burden of proof lies in this motion.
Okay. Mr. Ziegler, did you want to make any kind of opening, or were you ready to just proceed with testimony?
I reserve arguments for closing, Your Honor. We would call Trooper Dole.
Okay, Trooper Dole, if you come forward. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you. Please be seated in this chair here. And, if you would state your first and last name and spell both for the record.
Cody, K-O-E-D-Y, Dole, D-O-L-E.
Thank you. Mr. Ziegler, proceed whenever you're ready.
Thank you, Your Honor. Trooper Dole, what is your occupation?
A state trooper.
And how long have you worked in law enforcement?
4.5 years or so.
Were you on duty on December 2nd, 2022?
I was.
Did you have contact with an Anson Evans on that date?
I did.
When did you first speak with Mr. Evans that day?
It would have been probably around 2 or 3 o'clock that day.
In the afternoon?
Yes, sir.
And what was the purpose of that first meeting with Mr. Evans?
Mr. Evans had called the post requesting contact with law enforcement reference fraud complaint.
And did you have a discussion with Mr. Evans about that fraud complaint?
I did.
What was the nature of that complaint?
He made contact through a dating website with a female named Riley Timmer. He subsequently had given her credit card information, which she had used to try and purchase about $331 worth of Victoria's Secret.
Did he authorize her to make those types of purchases?
No.
Well, let me back up, I guess. During this conversation, did you make any efforts to try and determine what Mr. Evans's understanding was of Riley's age?
Yeah, so Mr. Evans believed Riley, or the female that he was talking with, to be born in, I believe it was 2002.
Did he say why you believe that?
Yes, he advised me that when he confronted her about fraudulent purchases or attempts of purchase, she had stated something regarding him getting in trouble for receiving explicit photographs of her being a minor.
She said he would get in trouble for that?
Correct.
Did he, based on his conversation with you, did he seem to believe that she was underage at the time?
He advised me that he did not think that she was underage when he received those photographs.
Okay. Did he make any statements at that time about having any explicit photographs of Riley Timmer?
He advised that he did receive explicit photographs from Mrs. Timmer, or from Riley Timmer, yes.
Did you view those at that time?
I did not at that time.
Did he describe what kinds of photographs he might have received at that time?
He advised that. I don't recall exactly.
Did you make any efforts to try and identify this Riley Timmer?
Did
you make any efforts to try and identify who this Riley Timmer individual was?
Yes, so Mr. Hanson had sent me photographs of Riley's face, or who he believed he had been talking with on this dating app. And I was able to contact Grand Rapids Sheriff's Office to make contact with Riley's father, who was able to identify Riley to be that photograph that Hanson had sent me.
And specifically, the information that you were provided determined that Riley was how old?
17 years old.
Specifically, what year was she born in, if you recall?
2005.
What did you do upon receiving that information from downstate?
I immediately went over to Hanson's house to check the evidence and CC evidence on Hanson's phone.
You recall about what time of day this would have been?
Approximately 8 or 9 o'clock at night.
Okay.
On the same day though.
And why did you feel it was necessary to proceed directly to Mr. Evans's house?
Mr. Evans already made it aware that he was told that she was underage. And because of the evidence being on a cell phone, I wanted to make sure that the evidence was protected as soon as possible.
Did you make any efforts at that time to obtain a search warrant?
Not at that time, no.
Why not?
I wanted to get that, I had probable cause to make a circumstance to seize the phone first off. And I did not think that I was gonna need a search warrant, because I already explained to Mr. Evans that I wouldn't be charging him with anything at that time due to his initial belief of her being under or over the legal age.
What happened when you arrived back at Mr. Evans's house that evening?
I asked Mr. Evans if I could go inside the residence, in which he invited me in. Mr. Evans had me sit down with him at the table, in which I advised him that Riley Timmer was in fact only 17 years old. And then I requested that Mr. Anson turn over his cell phone to me.
When you say he invited you in, can you describe where in the house you were welcomed into?
Yeah, so initially, Mr. Evans made contact me outside the house. I asked him to go inside and talk inside the residence. We initially go into the garage aspect of the house, in which he continued to lead through the house into the kitchen room or dining area.
Okay. So when you say a garage area, can you describe what you mean by that?
Yeah, so there's a vehicle parked in there, had a gravel or like a church rock flooring. Vehicle parked inside.
And then where is this room that you're describing as the room at the kitchen table? How do you get to that from the garage?
So if you go straight to the house or straight to the door of the house and invited in through, you go into the garage aspect of the residence. Then up 2 or 3 stairs directly to the left of that garage area, and that's that dining room area.
And then you sat down at the table with Mr. Evans?
Correct.
And I think you've already said that you asked at that time to take his phone.
Correct.
At some point, did you advise Mr. Evans that Ms. Timmer was underage?
Yes.
When did that occur?
Essentially, as soon as we had sat down, I advised him that we were able to confirm Riley Timmer as being Riley Timmer and her age of being 17 years old. And I advised him that I would require his phone.
And just so we're clear, this person who we've been describing as Mr. Evans and the person who invited you in that evening, is he present in the courtroom today?
He is. He's wearing a black blazer and a white t-shirt, khaki pants.
Your Honor, let the record reflect the witness identify the defendant.
Any objection?
No.
Did the defendant make any statements that he had nude photographs of Riley on his phone?
Yes, Mr. Anson advised me that he had Riley Timmer's pussy on his cell phone.
And what do you understand that term pussy to refer to?
It's a slang term used for vagina.
Did you ask him where his phone was located?
He advised it was inside the residence.
What was his demeanor at this time while you were having this conversation about his phone?
Panicked or flustered.
Did you request that he retrieve his phone?
I did.
Did he refuse to do that?
He did.
Did you order him to retrieve his phone?
I did.
Did he refuse to do that?
Initially.
Why did you feel like it was important for you to retrieve that phone immediately?
Because there was probable cause to believe that there was nude photographs of a minor on the cell phone and the cell phone data being easily destroyed or hidden.
Was there some discussion between you and the defendant following his refusal to turn over the cell phone?
Yes, there was concerns with Mr. Anson about why he didn't understand why this was happening.
And about how long did this discussion go on between you and him about turning over the phone?
Approximately 3 to 4 minutes
Okay. Where did that take place?
in the garage part of the residence.
At some point, do you tell him that he might be arrested for obstruction if he refuses to comply?
Yes,
Why did you tell him that?
I had a lawful reason to be there and I gave a lawful order. So I had probable cause to make a circumstance to protect and seize the evidence.
At some point, does he turn his phone over to you?
He does.
How did that occur?
He went into the bedroom, which I followed for my own safety, and he grabbed the cell phone, and as well as to make sure nothing was being deleted from the cell phone. Went into the garage instead of going to the left into the kitchen dining room area. We continued back farther through the I essentially believe it's gonna be the bedroom area next to a bed, grab the cell phone, hand it to me.
Did you ask him to retrieve another piece of electronic equipment at that time?
I asked if I could have his charger as well.
Did he turn that over to you?
Did.
Did he make any complaints about turning the charger over?
No.
Did you walk into the house and grab the phone yourself, or how did you obtain it?
It was handed to me by Mr. Evans.
After being handed the phone, did you ask the defendant to sign a consent to search form?
I did.
What is a consent to search form?
It's essentially saying that we're allowed to look through the phone, having the owner's permission to go and search through the phone.
Did he give you consent to search through the phone?
No, he did not.
Did you tell him that you would subsequently apply for a warrant for that phone?
I did.
And did you subsequently apply for a warrant to search through the data on the phone?
I did.
Do you recall when that warrant was applied for?
I was my next work day, which was the 7th.
Okay, let's talk about that for a minute. The phone was seized on December 2nd.
Correct.
Around what time of day did you say the phone was seized?
Approximately 8, 9 o'clock at night.
Do you recall what day of the week that was?
I do not.
Okay. I said it was a
It
Friday.
was Friday, yes.
Would you have any reason to dispute that?
No.
When would your next shift have been after the evening of December 2nd?
Would have been Wednesday, the 7th.
And did you apply for a search warrant to look through that phone at that time?
I did.
And was that search warrant signed by a magistrate?
It was.
Did you perform any searching of the phone prior to getting the search warrant signed?
No.
And what did you do with that phone after the search warrant?
It was packaged and sent over to the computer crimes unit.
There's been some allegations that there's a misstatement in that search warrant affidavit. Are you aware of that misstatement?
Yes, they're on the date. I believe it's the second paragraph. I put in the search warrant that Anton believed her to be born in 2005, and that is a typo. He believed her to be born 2002.
And that's what he told you during that first interview with him, correct?
Correct.
Did you intentionally lie in that search warrant affidavit?
I did not.
Did you have any intent to deceive the magistrate regarding the facts and circumstances of the investigation?
No, I did not.
Why does the search warrant affidavit say that Anson advised he believed Riley was born in 2005?
That was a typo.
Was that, those two dates of 2005 and 2002, they were both dates that were pertinent and a part of the investigation, correct?
That is correct.
I have no further questions.
Mr. Thompson?
Thank you. So Trooper Gold, there's no dispute here that you ordered Mr. Evans to give you his cell phone, correct?
Lawfully, correct.
There's no dispute that you ordered him to do it.
Correct.
Okay. And at the time, that was not in your immediate control or possession. That was in a different room, correct?
Correct.
All right. You didn't necessarily even know where the phone was when you encountered Mr. Evans.
Only that it was inside the residence.
Okay, so you essentially ordered him to search and obtain the phone and then bring it to you.
I did order him to bring the cell phone to me. That is correct.
Okay, from another room.
Correct.
Okay. Because he knew where it was. You didn't know where it
That is
was.
correct.
You would have had to search to obtain that phone if you had looked for it.
If I were to locate the phone in the residence, yes, I would have to go through the residence.
But this isn't a case where you initially obtained possession of the phone through anything other than your own orders.
Correct.
All right. And then at the point that you were given the phone, you seized the phone, correct?
Correct.
All right. And you believe that both the ordering Mr. Evans to search for the phone and seizing the phone, you believe that was lawful?
Sorry, say that again.
You believe that both ordering Mr. Evans to search for the phone and then seizing the phone, you believe both of those actions were lawful?
I believe I had probable cause to go and search and, or excuse me, to seize the evidence that was on the phone.
Okay. So is that a yes?
Correct.
You went there that day with the purpose of obtaining the cell phone, correct?
Correct.
All right. The exigent circumstances that you testified to is the fact that information on a cell phone can be deleted.
Or easily destroyed. Yes, sir.
Okay. In this particular circumstance, this first arose because Mr. Evans contacted you, correct?
That's correct.
All right, you testified about your initial conversation with him. Was that in person or on the phone, sir?
In person.
It was in person, okay. So he had already come into the station
Yeah.
by the point you then went to his house?
He had called the post,
Okay,
and then I was requested to make contact with him. I did have a conversation with him over the cell phone before going to his residence. The initial conversation was more or less just trying to locate his residence because it's marked weird in the GPS. I did not, as far as the fraud aspect of the complaint and the information, the investigation was all done in person at Mr. Anson's residence.
okay. The thing that made you want to go obtain the phone was that you had confirmed her age. Is that true?
That is correct.
Okay. So from your perspective, the exigency was the information you had obtained and then just the nature of a cell phone.
As well as him already sitting on the information that she may be underage from our initial contact.
Okay, but you believe that creates an exigency?
Correct.
So even though he approached law enforcement initially, you believed him approaching you created an exigency where you had to seize property?
Correct.
The only reason he knew that you'd confirmed or obtained this young woman's age is because you told him, correct?
Correct.
All right, there wasn't anything time sensitive or exigent about you discovering the information because you could have kept that to yourself, correct?
It depends on the matter of the sense, right? So he sat on the information that she may or may not be underage. After having that first contact with me, I didn't know how long it was going to be until he did destroy that evidence after already having conversation with law enforcement regarding the fact that she may be underage.
When you say sat on that, do you mean he delayed in disclosing that to you?
No, the fact that he sat there and waited for me to confirm her age after making contact with me the first time, how long was it going to be until he decided to destroy that evidence?
So you believe that even though he approached law enforcement initially, that he was at risk to destroy evidence?
Correct.
And other than the generalized risk that any defendant might destroy evidence, you can't point to anything in particular about this defendant that makes you think he would destroy evidence, can you?
That's right.
Okay. All right, so initially, obviously, Mr. Evans had been cooperative because he was the one approaching law enforcement, correct?
Correct.
So Mr. Evans did not consent to give you the phone. You ordered him to, correct?
Because I had probable cause of action for saying that is correct.
You testified that you swore up an affidavit for the search warrant, is that correct?
That's correct.
Okay. And that's 3 total pages, is that correct?
I don't recall the exact number of pages, but that sounds correct.
Okay. 14 total paragraphs. Does that sound correct?
That sounds correct, yes.
All right. Fair to say about half of that's boilerplate from another one you've done before, and about half of that is you putting in new information pertinent to this investigation?
No,
No, you didn't work off a template or a different case?
it was not my template, but I had used someone else's template.
Sure,
Correct.
sure. So,
Not mine, though, is your original question.
okay, thank you. So you used a template, so about half the language was already input, about half the language that ended up in the final search warrant. Is that an accurate, or a good guess?
I don't know about half. Some of the information was already, wording was already on there. Some of the wording was changed.
All right. Okay. And so you testified then under oath in the affidavit that Anson advised he believed Riley was born in 2005, and you acknowledge today that's an inaccurate statement.
Correct.
And you understand that by reading that statement, the magistrate would assume that, and sorry, this was applied for in 2022, correct?
That is correct.
All right, so anybody born in 2005, in 2022, that person would be underage, correct?
Correct, 17.
Okay. All right, and so if the magistrate read what you wrote, they would assume that Mr. Evans admitted he knew she was underage.
Correct.
All right, and that's not accurate.
That is not accurate.
Mr. Evans always told you he thought she was of age.
That's correct.
She was using a dating app that you're supposed to be 18 to use, and she represented herself as being over 18. Is that correct?
That's correct.
Okay. You said at one point in response to Mr. Ziegler's questions, you didn't believe you were going to need a warrant because you told him there wasn't going to be a charge. Can you expand on that? And if I misquoted you, please correct that, because I was writing pretty quickly.
I was not arresting Mr. Anson for possession of child pornography on that day. Was not charging him with anything on that day because he was led to believe that she was over the age. I was going to leave that to Mr. Ziegler.
So by that statement that you weren't charging him, do you mean that you did not have probable cause to charge him with that crime?
No, I was going to leave the decision to charge him. I'm not saying I didn't have probable cause. I did have probable cause to charge him with possession of child pornography at that time. However, due to Mr. Evans being led to believe that she was over the age, I did not think it was, I thought it would be better to leave it up to the prosecutor in this matter.
And did that lead you to conclude that you didn't need a search warrant because there wasn't going to be an initial charge?
Search warrant for,
The phone?
no, I seized the phone on probable cause exigent circumstances, so I did not need a search warrant.
Okay. When the prosecutor asked you about whether you had or needed a search warrant, you made a response indicating that you weren't initially going to be charging Mr. Evans.
Correct. They're on scene.
Okay. Does whether Mr. Evans is initially or immediately charged affect whether you need a warrant to search and seize as evidence?
No, but the probable cause and accident circumstance does.
Okay, so you agree whether you were going to initially charge him or whether that was going to be up to Mr. Ziegler, that wouldn't affect your legal right to order a search and a seizure of the phone?
Can you state the question again? I apologize.
Sure. Whether you were going to initially charge Mr. Evans or not doesn't affect whether you needed a search warrant to lawfully order him to search for and seize that phone or not.
Correct.
Okay, doesn't matter. All right. This 3 or 4 minute discussion with Mr. Evans, and it happened partly in his kitchen area and then partly in the garage. Do you agree with that?
Majority of it in the garage, but partially yes, in the kitchen area as well.
And that's where he refused to obtain the phone until you ordered.
Yes.
All right. When you applied for the search warrant, did you, what of the digital evidence on the phone were you asking to have searched?
Any of the cell phone showing child explicit materials.
You wanted the state police to have the authority to look through any electronic data on the phone. Is that accurate?
That showed proof of child explicit materials, correct?
All right. And so to look for that, you start with all the data on the phone and try to determine if there's anything that fits those requirements you just indicated.
I don't know how the CCU does what they do. So I don't know if I'm really in the right real testify to that.
Okay. On your affidavit for search warrant, did you fill out the paragraph 2 as defining the property to be searched and seized?
Yes.
Okay. And so if that read any electronic data contained within the cellular phone listed in section 1, including data stored on a SIM card or other media storage card device connected to or contained within the cell phone, that can be used as evidence of crimes related to sex crimes and CSAM to include but not limited to evidence of sexual touching, grooming, sending and receiving implicit images, possession with intent to deliver, delivery, use, and or sale of explicit images. Data may include but is not limited to the user phone book, the notebook, the date book, call logs, text messages, text data, email messages, multimedia messages, images, videos, electronic recordings, social media accounts, such as but not limited to all accounts for Snapchat, Instagram, Facebook, TikTok, and other social media apps. So that's how you define what you thought should be searched, correct?
Correct.
Okay. And you'd agree you were trying to be broad and essentially search through everything on the phone to look for evidence.
Every aspect of the crime, correct?
You didn't ask that the search be limited to his messages with this Miss Timmer, for example.
Correct.
How many further questions? Thank you.
You're.
Yeah, sorry. Just one moment, Your Honor, if I could have a moment.
Sure.
Okay. One other question, the prosecutor attorney indicated in his brief that one possibility you may have had as a law enforcement officer was detaining Mr. Evans until a search warrant could be obtained. Did you consider that option?
Did not consider it at that time. I've had several conversations regarding this case since then, and in the future, I'll be sure to do exactly that, so we don't have this issue in the future.
In the future, you will detain suspects
Correct,
and apply for a search warrant?
correct.
Is there a reason you didn't apply for a search warrant during the shift when you obtained the phone?
But initially, my contact with Mr. Evans was friendly. Upon the second time saying that I was gonna seize his phone, it became much more panicked and frustrated and not expect to have the unwillingness to comply.
After you obtained the phone, how much time did you have left in your shift?
Approximately 3 hours.
Why didn't you begin the process of applying for a search warrant during your shift that day?
I had no way of maintaining the cell phone data until I received a Faraday bag from the post, which from his residence over to the post is approximately an hour. At which time I then packaged the cell phone in a Faraday bag, prevent it being destroyed or deleted from other device.
How many further questions? Thank you. No.
Your, Ziegler, let me read that.
Very briefly, Your Honor. Testified on cross that you didn't know where the phone was when you arrived at Mr. Evans's house. Is that correct?
Other than it being inside the residence.
How did you know that, though?
Mr. Evans told me.
Have you ever had a suspect lie to you in the past?
Yes,
Is it possible that Mr. Evans was not being truthful about the location of the cell phone?
that is possible.
Did you have any reason to know that it wasn't somewhere else?
No,
Could it have been in his pocket, for example?
yes,
And you wouldn't have any reason to know that other than what he told you, correct?
correct.
Do you have a cell phone?
I do.
Are you familiar with the operation of a cellular telephone?
I am.
Particularly, have you sent and received text messages?
I have.
Do you know whether or not it's possible to delete individual text messages as opposed to an entire thread?
It is possible, yes.
Do you know whether it's possible to delete individual photographs from a text thread?
It
Your
is
Honor,
possible.
object as a lack of foundation.
Your Honor, I'd object in that the foundation was laid. I also object to Mr. Seeger objecting as it's not his witness.
Well, I mean, it's a fair point, Mr. Seeger. I don't let co-counsel kind of tag team things. So one of you has to be, making objections because I don't want to be dealing with a bunch of them. Either way, I mean, to me, this is like, this is 2023. I think generally people have cell phones. They're familiar with the operation of them. I haven't heard anything with the questions that Mr. Ziegler's asked, but I think it'd be outside the knowledge of anybody who has a cell phone. So, I mean, I don't think these questions are objectionable. So to that extent, I'll overrule.
Thank you, Your Honor.
If we get into something that's more technical, of course, counsel can
I'm
object.
So just to clarify that last question, to your knowledge, it's possible to delete an individual photograph from a text thread?
Yes, it's possible.
Based on your experience in using cell phones, is that a lengthy procedure to delete text or is that a quick procedure?
It's quick.
And same question about photographs. Is that a lengthy procedure or a quick procedure?
It's also quick.
No further questions.
Yes, just following up on those questions. You testified about your knowledge about removing photographs or text from a phone. Do you know if the hard drive of a phone keeps any record of those deletions?
I believe they do.
Okay.
I'm not 100% sure. I believe they do, yes.
Okay, not any further questions. Thank you.
Mr. Ziegler, any follow-up to that?
No, Your
Um, I guess I have a couple of questions because I need clarification based on the testimony, so, and it relates to direct, and I'll allow both counsel to inquire further into this after I get my answers. So what I have written in my notes based on the questions you were asked on direct was that during your first discussion with Mr. Evans, and this would have been on December 2nd at that 2 or 3 p.m. timeframe,
Yes, Your Honor.
that he relayed to you that Ms. Timmer told him that he could be in trouble for receiving photographs of a minor.
Oh, somewhere along those lines. I don't remember the exact verbiage of it, but it was somewhere along those lines. Yes, Your Honor.
All right, so before you confirmed Ms. Timmer's age, Mr. Evans had made statements to you indicating that she had some way told him that he may have received photos of a minor by receiving photos of her. But then he didn't think she was underage because of efforts that he had made to try and confirm that she was an adult.
Correct.
But in that earlier, that first interview with him at 2 or 3 o'clock on December 2nd, he also told you that he did receive explicit photos from her.
Correct.
I just needed that clarification. The other question I had for counsel was the search warrant or affidavit that admitted as evidence. Is there any reason why?
No, Your Honor, I have it.
It wasn't provided with the briefs, and I feel like I should have that.
If I may approach.
I thought it was an exhibit, Your Honor. Go ahead. I would stipulate to its admission, Your Honor.
Okay, so I'm just gonna admit that as court exhibit 1.
Thank you, Your Honor. That's I believe the full 3-page document.
Okay.
And that's the same document I was saying.
Thank you. So again, the court will mark and admit that as court exhibit 1. Mr. Ziegler, as to the previous questions that the court had.
Your Honor, could I see the document that was, I have a 4th page with the search warrant and the return tab, and I don't know if that's.
Oh, yeah, I had that's the affidavit and application. If you want there's also a search warrant and a return and tabulation. If the court would like those, I don't object to it. I just.
Yeah, I would prefer, because this is the copy that's signed by the magistrate.
Yeah, so the first 3 pages are what the witness signed, and then if prosecutor wants to add those additional 2 pages, that'd be fine.
Okay, very good. All right. Mr. Ziegler, any follow-up questions to the clarification that I requested?
Thank you, Your Honor. In your first meeting with Mr. Evans, you had a conversation about his interactions with Ms. Timmer, correct?
Correct.
At some point, did Mr. Evans tell you that Riley had conveyed to him that she was underage?
Correct.
Tell the court what you recall about that conversation.
So Mr. Anderson had advised he confronted Riley Timmer regarding the fraudulent purchases she attempted to make. And then she had responded saying somewhere, like I said, I don't remember the exact verbiage. He advised me that she had threatened to get him in trouble regarding her being underage.
Earlier in that conversation between Mr. Evans and Ms. Timmer, you were told by Mr. Evans that she had advised she was born in 2002. Is that correct?
Correct.
And then later in the conversation, she advised Mr. Evans that she was underage.
Correct.
Based on your conversations with Mr. Evans, did he appear to believe those assertions?
He didn't seem he was convinced either ways.
What do you mean by that?
He didn't seem to believe that she was either 100% over the age or 100% under the age. He was still going out and trying to find information to prove that she was one or the other.
Did he offer you reasons why he thought she was of age?
Yes.
Do you recall what those were?
One of them being that she had rented a hotel room. and that she has to be of a certain age to be able to rent a hotel room.
As you had a conversation with Mr. Evans at that first meeting, did he appear to you to continue to be concerned about Riley Timmer's age?
Yes.
I have no further questions.
You need a second, Mr. Thompson.
Yeah, just one second. You didn't have any knowledge about whether anybody else was in the house, correct?
Inside,
Mr. Evans's house, he advised you that he was there by himself, correct?
I don't remember, I don't recall. I don't remember knowing or not knowing if there was anyone else in the residence.
You didn't have any information that there was somebody else in.
Correct.
All right, and what Mr. Evans relayed to you on his initial complaint was that after he told this person that he was going to the police, that's when there was some sort of threat about there being underage photos.
Correct.
That was the context of it. Okay. All right. And you'd agree when you approached Mr. Evans and ultimately ordered the seizure of his phone, he wasn't in a motor vehicle at any point during that interaction, correct?
The second contact?
Yes.
Correct. No motor vehicle at that time.
All right, thank you. No further questions.
Thank you. Trooper, you can step down. Mr. Ziegler, did you have any additional witnesses? Mr. Thompson, any witnesses? from-
No, I did have, and I do understand that generally there's one inquisitor for each witness, but I did have one witness that I wish to call, which would be Deputy Shot.
Okay.
Your Honor, I would move to quash any subpoena for Sergeant Schaub at this time. Sergeant Schaub was not involved in this investigation. He's not a member of MSP. He doesn't have any personal knowledge as to the facts or circumstances of this case. Anything that he would testify to would either be hearsay or opinion testimony on the ultimate issue, which is not allowed. So I don't know what relevant testimony that witness could provide. I'd ask that he be excused at this time.
Mr. Seeger, can you give me an offer for?
Your Honor, so at least my understanding, generally speaking, would be that Officer Schaub would testify that in his opinion, based on conversations that he may have had with Mr. Ziegler together with who was sitting in the audience, Your Honor, is that Officer Dole did not follow standard law enforcement protocol, wherein the appropriate remedy would have been for Officer Dole to detain him, which I think the testimony of Officer Dole was something to the effect of, well, in subsequent instances, I will detain someone as opposed to forcing my way into their house or something to that extent, Your Honor, without a valid warrant. I think Officer Schaub would testify that the appropriate protocol in this case would have been for law enforcement, would have been for him to detain him and then subsequently apply for a warrant. So when we're talking about exigent circumstances, the way that Officer Dole's somewhat placing it, he's making it sound like there were exigent circumstances such that he needed to immediately enter into the house. The way that I understand it is it's not exigent in as much as if he's worried about something being destroyed, he didn't testify about knowing that anyone else was in the household or that there was a reason for him to destroy it. In fact, he didn't even know where the phone was. He said, Mr. Ziegler had asked him, well, is it possible that it was in his pocket? He didn't even know where the phone was at. So to that end, Your Honor, the only reason why I would call Officer Schaub, and if he was qualified as an expert, Your Honor, irrespective of whether or not he has personal knowledge in this case or not, he is able to render an opinion because he would be qualified as an expert. So I think it's at least relevant, Your Honor, and I think a record needs to be made because I personally believe, albeit it doesn't matter what I believe, Your Honor, that what Officer Dole was contrary to, it amounts to an illegal search and seizure. And so I think the record should be at least complete to the extent that he asks for an interlocutory appeal and the court does not find in his favor, which I think he's entitled to one way or another.
I guess I'm not understanding, I mean, to me, it's a legal question. I mean, the factual question here is what was the information that Trooper Dole had at the time that he took the actions of seizing the phone? What kind of factual information did he provide to the magistrate? And then was the search conducted within the parameters of the search warrant? And were those parameters correct? And to me, those are legal issues. The only factual issues are what information Trooper Dole had. And so Sergeant Shaw certainly could provide very qualified opinions about what he would do under these circumstances, or what any other trained law enforcement officer would do. But I don't know that I can rely on any opinions that Sergeant Shaw may have about what Deputy Dole should or shouldn't have done in determining whether or not there were exigent circumstances such that he could seize the phone and the issues related to the search.
Your Honor, the only other thing that I could offer is primarily, I think that in terms of whether or not Officer Dole followed law enforcement protocol is relevant to the court's decision. If the court does not agree with that, I think that he can testify in that manner, because part of the allegation is that he did not follow law enforcement protocol. If I understood the testimony correctly, Trooper Dole testified that he's been an officer for maybe 4.5 years or something to that effect. Wherein I'm pretty sure Officer Shaw has been a law enforcement officer for probably close to 30 years. So I think it's
unfortunately, I just disagree. I don't think whether he followed protocol or not is the question, because different departments, they have different protocols and different trainings. And the court isn't going to be determining whether he followed procedure or protocol. The court is determining whether it's a legal seizure and a legal search, and none of that depends on police protocol or what the particular agency's policy is. It depends on the facts and the law. So I still think that would be relevant. So I'm going to sustain the objection.
Your Honor, the last thing, and this is just because it was in the notes provided to me. I don't know if it's relevant to the court, but Officer Shaw had also contacted the troop or the post commander, Trooper McManus, or I'm not sure what his official title is, Sergeant McManus. And so he is familiar with the facts and circumstances of the case, and he also sat through the testimony as well.
Yeah, I suspect we could call in any number of different officers to listen to the facts and give me their opinions about what should or shouldn't have happened in this case. And unfortunately, that again, that's just not the standard that the court's looking at. So.
Your Honor, I guess I don't know if it's relevant to the court or not. If the court does not believe that Officer Shaw is the appropriate officer, if the court does not believe that protocol is relevant to the determination, then I would not call Trooper McManus or ask to call Trooper McManus. If the court does not believe that protocol is relevant to its determination of whether or not there was an illegal search and seizure.
Yeah, I don't. Okay. I think the standard I have to look at is what does the Constitution say? What does case law say?
Okay, thank you.
Okay, so no witnesses then for the defense other than what we've already discussed.
No.
Okay. Mr. Ziegler, argument.
Yeah, I just asked the Sergeant Shaw to be excused at this time.
Oh, I'm sorry, Sergeant Shaw, to the extent that you're under subpoena, I didn't know if he was actually under subpoena or if he was here.
He was subpoenaed for this offense. Thank you, Your Honor. In terms of argument, Your Honor, I'm sure the court has spent a lot of time reading through the written briefing. I don't want to spend a lot of time rehashing everything that's in my written brief, but largely I think the testimony today establishes, at the very least, the meat of the argument in terms of probable cause plus exigent circumstances, which is that there were significant concerns in this officer's mind about destruction of evidence on the cell phone. Court is well aware from the testimony and from probably its own personal experience that data on cell phones can easily be deleted. It can quickly be deleted. And so there is a legitimate law enforcement concern in making sure that that evidence is not destroyed. There's plenty of case law to the effect that law enforcement is allowed to seize a container in order to preserve its contents pending the application for a search warrant. In particular, the case that I cited in my brief was the El Whaley case. which also involved a cell phone, where officers seized that phone. And Al Whaley Court specifically found that that was lawful. You can seize a container to prevent destruction of evidence, particularly here where there are concerns about destruction of evidence that falls under probable cause plus exigent circumstances. So I do think while there is a certain lack of cases regarding cell phones and cell phone data, this is a cutting edge area of the law at this time. Those cases, or at least one of them, I believe, was unpublished. I do believe that the Al Yassiri and the Al Whaley cases are directly on point for this case, where officers were faced with similar concerns about destruction of evidence on a cell phone. In both of those cases, the officers seized those cell phones in order to preserve the evidence on the phones. Courts did not have a problem with that, particularly where subsequently to that seizure, they applied for a search warrant. And that's exactly what happened in this case as well, Your Honor. The officer testified today that the seizure took place on December 2nd. It was nearing the end of his shift. He had to get that phone back from the evidence room, get it into a Faraday bag, which is a bag which prevents incoming and outgoing electronic signals. That's so that the information on that phone cannot be remotely wiped. At his very next shift, he applied for that search warrant. That also plays into my second argument about inevitable discovery, Your Honor, that in this case, we don't have to rely on some hypothetical search warrant. We actually did get a search warrant in this case. We don't have to worry about what the magistrate might have done or what a magistrate could have done. We know what the magistrate actually did in this case, which was authorize a search of that phone. So I think the testimony today establishes either that this was a probable cause plus exigent circumstances seizure of the phone, and then a subsequent search warrant for the data on that phone, which is permissible, or that data on that phone, even assuming there was some technical issue with the procedure, was inevitably discoverable by the search warrant. The defense does not get to argue that the defendant could have tampered with the evidence to prevent its discovery. So I don't want to belabor the point, Your Honor. I know the court has read all 19 pages of my response. Unless the court has any questions, thank you.
No, thanks. Mr. Thompson.
Thank you, Your Honor. Again, I know that we've read our briefing. I am struck by some of the similarities and some of the differences with this court's case in People versus Bruce, which I know the court is very familiar with from Otsego County. That case also hinged on exigency, and I think the facts here are very different. In this case, I would submit to the court that the prosecution is essentially relying on the argument rejected by Riley versus California that all evidence on a cell phone is inherently deletable or could be lost, and so all cell phones should essentially be exigent circumstances in and of themselves. That argument was rejected in Riley versus California. There is still a requirement of showing a particular need to search and or seize a cell phone, Your Honor. In this one, essentially, I believe that's what the government's position boils down to is we believe that evidence could have been lost. I don't believe they've submitted any evidence that would lead a rational officer to conclude that the evidence was about to be lost. And when I contrast that with Bruce, and Bruce, the court may recall, the suspect had already bought a new cell phone. He wasn't even using that cell phone anymore that was alleged to have contained photographs. So and that was his first encounter with the police, knowing that they were suspecting him, knowing that they wanted to look at that phone, knowing that there may be evidence of a crime on that, and that police were investigating. In this matter, Mr. Evans approached the police because he was the victim of a crime. There's no reason to believe that in the time it takes to get a cell phone that he would have said, I completely changed my mind about pursuing this crime and talking to law enforcement, and now I'm going to start deleting things. That's just, there's no basis for that, Your Honor. The only exigency that night was created by Trooper Dole deciding that he wanted that phone right then. So he went there, and Your Honor, I would respectfully submit that is both a search and a seizure when he goes into the home, orders Mr. Evans to essentially perform the search that he can't or shouldn't have constitutionally been permitted to do, to go into the room and obtain the phone. Finally, Your Honor, the prosecutor wants to rely on the magistrate signing the search warrant application. Respectfully, Your Honor, there's a huge defect in that search warrant application where the way the trooper wrote the application. It's a complete misstatement that sounds like the defendant admitted that he knew this person was underage, and that's not the case. We heard that today, Your Honor. And so we don't believe that search warrant justifies or bolsters the search. That's our position. Thank you.
Thank you. It's your burden, Mr. Ziegler, any response?
Just a couple of points, Your Honor. The defense stated in their closing that it's the people's position that all cell phones create exigency. That's certainly not the case. People did not say that in the brief. I'm not saying it today. The exigency in this case is that the defendant had reason to know or reason to believe that law enforcement were pursuing an investigation into child sexually explicit material on his cell phone. He made those concerns known to the officer at his first meeting with the officer. And when the officer returned, he explicitly told the defendant that the victim in this case, or the suspect, Ms. Timmer, however you want to characterize her involvement, that she was underage. So at either of those times, there's good reason to know or believe that Mr. Evans knew his phone contained child sexually abusive material. So where the suspect knows that his phone has that kind of evidence on it, then there arises the opportunity for him to delete that evidence, to exculpate himself from any potential investigation. If he didn't have those suspicions in the first instance, perhaps it could be argued that there was no reason for the trooper to go there and for the trooper to inform him of that and to try and get the phone immediately. But based on Trooper Dole's testimony to the court's question about that first conversation, it's clear that while Mr. Evans was making statements to the effect that he was told that she was overage and he had some reasons to believe that she was overage, there was certainly some concern in his mind and in his demeanor and in his conversation with the officer that she was underage. So in the trooper's mind, every minute that he delays in returning to seize that phone is another minute where the defendant has an opportunity to either destroy the phone or hide the phone, remove all the evidence from the phone, or remove specific pieces of evidence from that phone that would better his case. So I think that is what creates the exigency in this case. It's not our position, nor would it be that anytime there's a cell phone with evidence on it that police can just seize it. That's certainly not our position. As to the defect in the search warrant that was raised by the defense, Your Honor, I've cited that case law in my brief. I don't think the defect in the search warrant was intentional, but even if it was, I don't see that that changes whether or not probable cause existed to seize that phone or to search that phone. There's no question in this case that probable cause existed. I don't know if the defense is disputing that, but I don't think they are. It's clear that the defendant stated, at least at the second interview, that there was a photograph of Ms. Timmer's vagina on his phone. And at that time, he knew she was underage. So it was quite clear to me, quite clear to the officer, quite clear to the magistrate that there was probable cause to believe that image was on his phone. What the defendant believed about her age at that point is not relevant. The evidence would still be present on the phone, or there would be probable cause to believe that it would still be present. So the search warrant should stand regardless of the defect. Thank you.
All right, I do want a few moments, since I didn't have it before, to review the search warrant and the affidavit. So we're going to take a short recess, but the court will be back as quickly as possible. We're back on the record in People versus Evans. Had a chance to go through the testimony of Trooper Dole. Look at Court Exhibit 1, which is the affidavit and search warrant at issue in this case, as well as just consider the arguments of the parties as presented here today orally on the record as well as in writing. And in the court's view, the defendant's motion raises two basic issues. Number one, we have a warrantless seizure of the phone. Was that proper? And number two, the search warrant that was obtained to search the phone, was that invalid either because it contained incorrect information or because it was overbroad? So looking at the first issue, which is the seizure of the phone, the warrantless seizure, prosecutors put forward a number of different potential exceptions to the warrant requirement before a seizure like this could occur. And the court finds that the one most applicable in this case is the exigent circumstances exception. That states essentially that where there's some type of emergency in existence, where there's no time to get a warrant, and where law enforcement has probable cause that the item will contain evidence of a crime, that can create an exception to the warrant requirement. In order for circumstances to be exigent, the seizure must be immediately necessary to prevent some type of imminent destruction of evidence, or that's the one that applies in this case in terms of exigent circumstances. And looking at the case law involving seizures of cell phones, because it does present a different type of potential destruction of evidence. In other words, the deletion of material on a cell phone without destroying the cell phone itself. It's different, obviously, than burning papers or throwing a weapon into the bottom of a lake or something like that. A cell phone can have information on the cell phone deleted or made more difficult to obtain or even wiped completely without destroying the cell phone itself and without the individual even necessarily having possession of the phone, which is part of the reason for the Faraday bag. Electronic devices can be wiped with information by remote means without the person even having it. So sometimes even the seizure of a cell phone doesn't necessarily prevent the destruction of the evidence on that cell phone itself. So the cases that have looked at this kind of issue have drawn a line between just seizing any cell phone, as in the Riley versus California case, or what type of justification does law enforcement need to have to seize a cell phone for the reason of protecting or preventing the destruction of evidence. And I think the cases come out with a standard that is, where a defendant knows they're being investigated, where law enforcement wants to see the photos and the defendant's aware of that, that can equal a legitimate concern on the part of law enforcement that the defendant may try to destroy the phone itself or its contents. And that's from the Bruce case, that's from some of the other cases cited by the parties here. And so it's all about what kind of knowledge does a defendant have regarding an investigation and where it's going that would give a defendant a motivation to want to try to destroy or wipe evidence from a cell phone. And if those circumstances are in place, then that can give rise to a legitimate concern by law enforcement that evidence may be destroyed and lead to exigent circumstances. And then the court, in addition to having that concern for imminent destruction of evidence, legitimate concern, I should say, then law enforcement also has to have probable cause. That is, the facts and circumstances known to law enforcement at the time would lead a reasonable person to believe that a crime's been committed and that evidence of that crime would be found in a particular place. So there needs to be exigent circumstances and probable cause. In this case, looking at the exigent circumstances component of this, based on the defendant's conversation with Trooper Dole in the early afternoon, 2 or 3 o'clock of December 2nd of 2022, based on that conversation with Trooper Dole and his statements to Trooper Dole, the defendant at that time had at least some knowledge that Timmer may be under the age of 18, based on her own statements to him and her threats to him, that she could try to get him in trouble for having pictures of her while she's underage. The defendant's also aware, of course, at that time that he does actually have at least one picture of Timmer on his phone. While that investigation did start out as an investigation into his claims of fraud, again, when you look at the totality of the discussion as it exists here on the record, based on the testimony of Trooper Dole, I think a reasonable person in the defense position at the time would know that that's a matter of interest to Trooper Dole, that that's something he's looking into, is the age of Timmer and the fact that he's admitted to having inappropriate photos, or at least one of her on his phone. Trooper Dole leaves that situation. He does some further investigation and obtains definitive information that Timmer was under the age of 18 at the time. So as of that point, certainly there's information that phone contains potential evidence of a crime. So Trooper Dole returns, he informs the defendant that he's now obtained information that she is underage. So at that point, now the defendant certainly knows that he's under investigation, because now Trooper Dole is back again. The defendant certainly knows that there are potential incriminating photos on his phone, and he knows that Trooper Dole looked at that phone. So at that point, certainly there arises a legitimate concern that the defendant would want to try to destroy some of that information on his phone. The question is, does Trooper Dole create that exigency or that concern by divulging that information to the defendant? In other words, if he doesn't know that Trooper Dole knows that Timmer is actually underage, then that doesn't create any additional motivation for the defendant to want to destroy the evidence. But in my view, based on the information that Trooper Dole had at the time of the first interview, I think he arguably could have seized the phone at that time based solely on the information that he had. Certainly the additional information does provide added motivation to the defendant to potentially want to destroy that information. And so therefore provides added motivation on the part of law enforcement to seize that phone to prevent the destruction of that evidence. But again, I think the exigency already exists, and I think Trooper Dole arguably took a chance in allowing the defendant to keep that phone after the first interview, and that evidence could be destroyed even after the first interview. Even if it could be said that Trooper Dole created the exigency by informing the defendant, I think in order for the court to suppress evidence based on that, I think there would have to be some finding by the court that Trooper Dole had an intent to create the exigency by divulging that information, or some kind of willful conduct to circumvent the reasonableness of the seizure or the unreasonableness of the seizure by intentionally divulging that information to create the exigency and then give himself justification for seizing the phone. I don't think there's any evidence that Trooper Dole did that, and I think Trooper Dole's testimony actually establishes that once he had the information that Timmer was definitely underage, that it was his intent to seize the phone. So whether he divulged to the defendant that information or not, he was going to seize that phone at that time. So again, I think that's evidence that there wasn't some kind of willful fabrication of an exigency. So all of that to say that I think there was a sufficient exigency at the time of the first interview. Certainly at the time of the second interview, there was a sufficient exigency to allow law enforcement to seize that, because at that point the defendant knew he was being investigated. He knew they wanted to see the photos or what was on the phone, and that gives rise to a legitimate concern on the part of law enforcement that the defendant could try to destroy the phone or its contents. And so therefore the court finds the first prong of that exception to exist. And the second prong, which is probable cause, clearly there's probable cause here. Law enforcement's aware that Ms. Timmer is under the age of 18. Mr. Evans at that point had between the two interviews had made several statements that he had inappropriate pictures of her on his phone. So clearly a reasonable person would believe that a crime had been committed and that there was evidence to be found of that on his phone. So for all those reasons, the court finds that there was a proper seizure of the phone in this case, or a justified seizure without a warrant, and the motion is denied on those grounds. With regard to the warrant itself, looking at the statements within the warrant, there is a statement at paragraph 4 indicating Anson advised he believed Riley was born in 2005. That's been acknowledged that that's an incorrect statement of fact. However, the court doesn't find that that affects the validity of the warrant. That only states what Mr. Evans' belief was, and it really only states what he told Trooper Dole his belief was. That particular information I don't think is pertinent to a justification for the magistrate to issue a search warrant. The court finds that the pertinent information is found at paragraphs 7 and 8, and that's where Trooper Dole testifies through the affidavit that the individual female is under the age of 18, that she's 17 years old, and that Mr. Evans has admitted that he's received photographs of her private areas. So whether or not Mr. Evans believed she was born in 2005 really is irrelevant to whether or not there was probable cause to search and the issuance of the warrant. So the court finds that to the extent that that was an error, it doesn't affect the validity of the warrant. In terms of the breadth of the warrant, certainly there's case law that holds that warrants, that the extent of the warrant has to be limited to the type of crime that's being investigated. In this case, the warrant limits the search to evidence of crimes that are related to sex crimes, child sexually abusive material, sexual touching, grooming, and so forth, as stated in the warrant. I think the defense would have a better argument here if there was evidence during the search of that phone uncovered to show, the crimes of theft or drugs or some other crime unrelated to child sexually abusive material, and that was outside the scope of the warrant. But in this case, the warrant's limited to a search for those types of materials. Officers and law enforcement are entitled to conduct reasonably thorough searches of devices in order to uncover evidence of crimes stated within the warrant. There isn't any evidence that it went beyond that in this case, and the evidence that it was uncovered, even though it didn't necessarily relate to Ms. Timmer, it certainly did relate to the crime stated in the warrant. So to that extent, it's not outside the scope, and the court doesn't find that the warrant was overbroad to the extent that it allowed searching for things other than the crimes that were listed in the warrant. And again, to the extent that there could have been other crimes uncovered, then maybe it would be overbroad, and those types of evidence of those crimes would have to be suppressed. But in this case, the court finds that the warrant was not invalid for the reasons argued by the defense, and the court denies the motion to suppress. Mr. Thompson and Mr. Seager, I would request that you prepare an order reflecting the ruling of the court today, and either submit that with stipulation as to form or under the 7-day rule. Mr. Ziegler, anything else we need to address for the people today?
Your Honor, I can prepare that order. Would the court prefer an order that says for the reasons stated on the record, or would the court like us to try to summarize the court's ruling?
No, just, reasons stated on the record.
Thank you, Your Honor.
Okay.
You can say my name.
Your Honor, additionally, and it's just a note, there was a case that came out, and I'm forgetting the name of the case, Your Honor, but that essentially allows him to ask for an interlocutory appeal. And just in speaking with Mr. Evans, it's my understanding that he wishes to pursue that avenue. And so I'm not sure if the time tolls from the date that the order was signed, Your Honor, the interlocutory appeal, but I assume that shortly after the order was signed, the time will start tolling for the appeal to be filed or created.
but an appellate attorney, which I can give him a referral to, or he can seek out his own counsel relative to that. But it is his intent to request it, so I just wanted to verify that the court would allow him to have an interlocutory appeal to the extent that he provides notice to the court and all parties.
I mean, honestly, I haven't researched the issue of an interlocutory appeal, whether it would be appropriate in this situation or not, so I'm really not prepared to rule on any of those things. I think Mr. Evans is entitled to make whatever appeals the court rules statute allow him to make, and I would expect that he would, so. I'll leave that up to you and appellate counsel to hash that out. Okay.
Thank you.
Thank you. And then just so everybody's aware, I do have another hearing that I have to go on the record on at 3 o'clock. I'm gonna take a short break, but you could all exit the courtroom quietly. Please. Thanks. Susie, are you able to hear me okay?
Yes, sir.
Okay, I'm gonna bring everybody else in here.
Is the jail connected? Do I need to call them?
It looks like they're connected, so I think we're good to go.
Okay.
All right, Mr. Earler, are you able to hear me okay?
Yes, Your Honor. How are you doing today, sir?
Good, thank you. All right, Mr. Trush and Mr. Fenton, are you both able to hear me?
Yes.
Yes, Your Honor.
Okay, thank you. All right, we'll go on the record. This is People versus Allard, case number 236520, 6521, 6522, and 6523. The record should reflect that Mr. Allard is present today by video from the Otsego County Jail. If I could have counsel put your appearances on.
Stuart Fenton for the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Ellert for duty purposes.
Okay, so Mr. Allard, at this time, you do not have a lawyer, is that correct?
I'm in the process of finally hiring one. I met one yesterday, sir.
Okay. Do you understand why you're before the court today?
Yes, I do, Your Honor.
Okay, you're before the court today because you failed to appear at a hearing back on August 21st of 2023 in each of these files. Do you understand that you do have the right to have an attorney, and if you could not afford one, that the court would appoint one for you at public expense?
Yes, sir.
And that Mr. Trush is here for purposes of arraignment today, and that if you wanted to ask any advice, that he is available and could advise you if you wanted to speak to him.
Okay.
All right.
Your Honor, just to,
Mr. Yeah, go ahead.
I say, just to make it clear, I did meet with Mr. Ellert prior to the hearing. I spoke to him just before we logged in here. Mr. Gilo has screened him potentially for counsel and determined that he does not qualify. By way of the non-appearance, I do have an address to update the court with. It does appear that the addresses the court has, some of them are woefully out of date. One of them's an address he's never lived at, one he hasn't lived at since 2022, and the other one he hasn't lived at since January of 2023. We do have an updated address for the court.
Okay, why don't you go ahead and provide that for us, please?
Okay. So that is 221 East Michigan Avenue, 272 Grass Lake, Michigan, 49240.
All right, thank you. So Mr. Allard, the PO box in Grass Lake, that's not an accurate address for you anymore?
Oh, unfortunately not. What happened is when I moved at that present time, I did communicate that with the court. And I don't know what happened at that present time, so.
Okay. All right, Mr. Allard, you are charged with contempt for your failure to appear. If you're found guilty of contempt for failing to appear, then you could be subject to a penalty of up to 93 days in jail and or a $500 fine. Do you understand that?
Yes.
Also, because your bond was revoked because you failed to appear at the previous hearing, you do have the right to have a new bond set. And if you can post that to be released pending the next hearing, do you understand those things?
Yes, I do.
All right. So in terms of bond, Mr. Fenton, did the people have any position with regard to what bond the court should set going forward?
Yes, Judge, we have a strong opinion. The defendant has 4 cases in circuit and a 5th in district. They're all felonies. He was just arraigned on the 5th case in district court an hour ago or so. Judge Cooper set a $10,000 bond at my request. The defendant has, between the 5 files now, approximately 26 counts, all involving fraud and financial crimes. His reputation is not trustworthy. He owes over $15,000 in monies to various victims between all the cases. It's certainly his obligation and his responsibility to update the court if he has a change of address. He would have signed bond paperwork that told him expressly that. He failed to do so. He's been missing since August. I would submit that $10,000 cash or surety bond in each case would be appropriate and have him basically held until trial.
All right, thank you. Mr. Allard, anything that you wanted to say with regard to the amount of bond in this case?
Yes, Your Honor. Mr. Fenton did point out that I didn't update the court, and I know very much well with my bond. I have all my paperwork that was given to me at that present time. As soon as I did update my address, I did update the court. I'm very trustworthy. I've not missed a single court case in front of you at this present time until I never received any documentation. And then in front of Judge Cooper, I never missed any court case with him either. So this is the first time I ever missed any single thing at that present time. I wasn't, as Mr. Fenton says, I wasn't, I don't want to say running. I wasn't running. I just didn't know. I contacted the court to get my next court date. They said that it'll be in the mail. I looked online through the court. It wasn't updated there. The only reason I found out I had a bench warrant was last week. At that present time, when I did found out I had a bench warrant, I pulled my iChat. I contacted the district court saying, hey, I just found out that I had a bench warrant. I'll be up in December to turn myself in. I sincerely do apologize at that present time.
Okay. How did you get arrested here today or yesterday?
So at that present time, I was at my address, and the police came to my house. I didn't know I had a warrant. I didn't at that present time. I knew I had a bench warrant, and I had everything I thought sorted out to get turned back in, so that way I could fix it. Because I respect you, and I respect Judge Cooper, and I respect Otsego County. But I didn't know I had another warrant that was issued on September 11th because it didn't populate up through iChat.
Judge, can I say something?
Yes.
That notice for the August 21st was mailed out to him on June 21st, and it never came back from the post office. So I just wanted to make that on the record that we had the PO Box 272. It was mailed out on June 21st for August 21st at 11:15. And we didn't receive anything back that the box was closed or he never got it, just so you're aware.
Okay. All right. So Mr. Eller, the court has to look at a number of different things when making decisions about bond, whether you have any local ties to the community, whether you live locally or out of town, the number of charges that you have, the severity of the charges that you have, any prior failures to appear, and the maximum possible penalties that you could face if you're ultimately convicted, as well as issues like substance abuse or danger to the community and so forth. In this case, the court does have concerns about the address issue. Clearly, that's something that the court should have been updated on. It doesn't appear that the mail returned to us. So from the court standpoint, the notices are getting to you, and it's your obligation to get yourself to court when you're supposed to be there. Also, I know the court gave you a lot of time to try to get an attorney before. It doesn't appear that you've done that yet. So there hasn't been any progress on your part, and I don't want to hear whatever excuse you have for doing it, because you just haven't done it yet, and you've had more than enough time to obtain counsel. So you haven't done anything to move forward with your case either. You've just apparently just been waiting until you were ready to come turn yourself in to the court and get this taken care of. So for those reasons, the court does have concerns that you would appear in the future. And so the court finds that a higher bond is necessary to ensure your appearance, given that you are not residing locally. So for those reasons, the court finds that the suggestion of the prosecutor is an appropriate amount to ensure your appearance, and the court will set bond in the amount of $10,000 cash or surety on each of the 4 files here. The court will enter a not guilty plea on your behalf with regard to the contempt charge for your failure to appear, and we can address that along with the rest of your cases. The court will set this for a hearing at the court's next available date. If you're able to post bond, Mr. Eller, then the court will send that notice to the address you provided today. And if not, then the court will provide you with notice of that at the jail. Mr. Fenton, is there anything else we need to address from your
Your Honor,
side?
thank you.
Mr. Eller, do you have any questions about how we're going to go forward?
Your Honor, so as long as I'm able to post bond through cash or surety at that present time, I'll be getting notice through the current mailing address, correct? And all my bond that originally stood is going to be the same rules that apply, correct?
The same rules are going to apply, and the address that we got today, I mean, is that the correct address, or is there a different address?
No, that's the correct address, sir. It's been the correct address since I notified the court, Your Honor.
I don't know whether you actually notified the court or not, because we don't have the new address that you've just given us today on our records. So as long as the one that you gave us today is the right one, that's the one we're going to send notice to. If you have any questions, you can contact the court at any time. If you don't receive notices, or you think you're not receiving things, proper move is to correct the court, not to just wait and hope that nothing's going to happen. That's all we have for today. The court's going to go ahead and